In negligence actions, a plaintiff must generally prove that the defendant was the cause in fact of his or her injuries. However, if there are multiple tortfeasors, a plaintiff may not be able to determine which one of them caused his or her injuries, although it's clear one of them did. Under these circumstances, the doctrine of alternative liability allows a plaintiff to shift the burden of proof to the defendants to prove they didn't cause the plaintiff harm. But what if only one of the potential tortfeasors is named in the action? Does the doctrine of alternative liability still apply? This was the question for the Ohio Court of Appeals in Burke v. Schaffner. In October of 1993, Gary Burke, Martin Malone, and Kerri Schaffner attended a party for police officers at a precinct in Columbus, Ohio. After the party, Malone was seated in the driver's seat of his pickup truck, which was stationary but running. At the same time, Schaffner was seated in the passenger seat of the truck. But as Schaffner moved from the truck's passenger seat to the back seat to make room for other passengers, Schaffner or Malone accidentally stepped on the truck's gas pedal, causing the truck to jerk and accelerate. As the truck accelerated, it struck Gary Burke, pinning him between the truck and a parked car, causing him to sustain serious injuries. After settling with Malone outside of court, Burke and his wife Tammy sued Schaffner in the Court of Common Pleas based on negligence. Prior to trial, Schaffner moved for summary judgment, claiming she didn't cause Burke's injuries. The Burkes opposed the motion, relying on Malone's deposition testimony where he denied fault. The court denied Schaffner's motion, holding that genuine issues of material fact existed as to who stepped on the truck's gas pedal. The case proceeded to trial, and following the Burkes' presentation of evidence, Schaffner's attorney rested without calling any witnesses. The Burkes' attorney then sought to reopen the case to call Schaffner as a rebuttal witness, but was unsuccessful. In addition, the Burkes' attorney submitted a proposed jury instruction on the doctrine of alternative liability. Specifically, the Burkes asked the court to instruct the jury that because Schaffner didn't testify or present any evidence, she didn't meet her burden of proving that she wasn't negligent. The court denied the request, and the jury returned a verdict in favor of Schaffner. The court then entered judgment on the jury's verdict. The Burkes appealed to the Ohio Court of Appeals.